Right. Very warm welcome to everyone to another Stewart's Law expert witness training session. Today the topic is contributory negligence. We're looking at it from the aspect of road traffic claims, and increasingly we meet this allegation in clinical negligence cases. We have two speakers today. Isaac Hogarth of counsel from a reputable specialist set of 12 King's Bench Walk. He actually started his legal career, I hope I'm right in saying, as a paralegal at Stewart's, and we're very proud to welcome him today as a speaker. Our other speaker, who will deal with the medical aspects, will be very well known to most, if not all of you. A highly experienced neurosurgery expert, Nick Todd, who will be giving his view from the medical aspects of road traffic injuries. If you don't mind, if anyone has any questions, if we could use the chat facility, and we will pick up questions at the end after the second of the talks, if that's okay. I'll hand you straight over to Isaac.
Thank you very much, Nick. I am going to try to share my screen, so just bear with me one moment. Right, with any luck, you can see my slides. So as Nick said, I'm counsel at 12 KBW. I do a mixture of clinical negligence and personal injury law. I think looking down the list of names here, many of you know me, probably predominantly from a clin neg setting. I've been asked to speak for about 20 to 25 minutes on the legal aspects of contributory negligence, particularly in road traffic accidents and clinical negligence. So what I'm going to do, this is the sort of running order of what I'm going to try and cover. A little bit of legal background, first of all, and then I'll talk about some of the typical contributory negligence arguments that we see in the context of RTAs, and then clinical negligence. And I'll try and pick up on a few key points for you as experts to be aware of and to look out for. Apologies for those of you who have some legal training as well, because some of this may seem a little basic, but this is the important legal background. Contributory negligence is a partial defence. It used to be the case pre-1945 that it would be a complete defence if made out. But post-1945, as set out in the Act, which I'll come to in a second, it is a partial defence. It's got to be raised by the defendant. It's got to be pleaded by the defendant. That means it needs to be raised in their formal defence at the start of the claim once litigated. That's obviously so because everyone needs to know it's an issue so that the issues can be properly addressed. Everything that you really need to know in terms of what the law sees clinical negligence as, contributory negligence as being, is set out in section 1.1 of the Law Reform Contributory Negligence Act. And I'm afraid I'm going to read out this paragraph because this is really the key part of it. Where any person suffers damage as the result partly of his own fault and partly of the fault of any other person or persons, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So whilst slightly archaic, I think the language there is very clear, and I just want to break that down a little bit. What does the claimant suffering damage as the result partly of his own fault mean? It can really mean two things: either contribution to the occurrence of the damage, the fact that there has been damage at all, or contribution to the extent of damage, i.e. how bad the injury is as a result of that fault. Obviously, it can also be both those things combined. If the damage or the accident has been caused entirely by the claimant's own fault, then there can't be any claim against the defendant. Any claim will fail entirely because there won't be any causation. because all the causation will flow from the claimant's own fault. If the claimant is blameworthy in some way, has done something wrong that would be a breach of duty, and I will talk about that a little bit further in a moment, but the breach by the claimant has made no contribution to the damage as a matter of causation, so there is blameworthiness but no causation, then there won't be any contributory negligence, there won't be any deduction from the damages. And there's a quote there from Lord Atkin: if the claimant were negligent, but his negligence was not a cause operating to produce the damage, there would be no defence. I find it impossible to divorce any theory of contributory negligence from the concept of causation. So we are always, in other words, looking at both blameworthiness and causation together. Both of those elements need to be present in order for the court to make any reduction for contributory negligence. Standard of care, well, the standard of care on the claimant is what is reasonable in the circumstances. That's the same test that we apply generally in the law of negligence. So a person is guilty of contributory negligence if he ought to have foreseen that, if he did not act prudently or with reasonable care, he might suffer injury. I think it's probably fair to say that, as with most of the common law, and certainly the law of negligence, this is simply an application of common sense. And it sounds like this might be rather subjective, what's reasonable and what's not. But obviously, these are the sorts of standards that we all apply and you as experts apply every day. It is, in theory at least, an objective standard. But the claimant needs to take account of the possibility of others being careless. That's something that comes up on the road very often. But there must have been some opportunity by the claimant to avoid the injury or avoid the extent of injury. The law judges the standard in reference to a reasonable person in the claimant's position, but will account for the claimant's own individual circumstances. So children, and obviously we see a lot of children cases in RTAs, particularly pedestrians. They're not to be judged by the same standard as adults. The extent to which blame will be attributed to them depends on their age. Also, if a claimant is under a disability or lacks capacity, for instance, that's going to be taken into account when determining whether a person in their circumstances ought to have acted in a different manner in order to lessen or avoid injury. So I'm going to have a look now at a few different categories where there are bodies of case law that have arisen which determine how contributory negligence is to be approached. The seatbelts is probably one of the areas where many of you are asked to comment most frequently. And the leading case, which everyone working in this area needs to be aware of, is Froome and Butcher. It's an old case, so probably everyone knows it well. But the Court of Appeal gave some fairly rigid guidance in that case on seatbelts. And essentially, it's the case that if the injury would have been avoided altogether had a seatbelt been worn, then there is a reduction of 25% for contributory negligence. If there would still have been some injury, but it would have been less severe, then there is a fixed reduction of 15%. I should say that Froome is one of these cases that has acquired quasi-statutory status. And that's really driven home by the decision in Stanton and Collinson, which was a case where there was an attempt in 2010 to challenge Froome. And there were some good points made to try and challenge Froome in that case, because the points were taken that seatbelts are now compulsory, whereas they weren't in 1976. Seatbelts are safer and more efficacious than they previously were, and seatbelt use is very common. The Court of Appeal weren't convinced by that, and Lord Justice Hughes said this: "There may, I accept, be unusual cases in which the two brackets of finding contemplated by Froome are neither appropriate. But the Act, that's the Contributory Negligence Act of 1945, requires that the reduction for contributory negligence shall be such as appears to the court to be just and equitable. It therefore permits an approach such as adopted in Froome, based upon two broad categories of typical case and the general proposition that absent something exceptional, there should be no reduction in a case where the injury would not have been reduced to a considerable extent by the seatbelt. And what the Court of Appeal is trying to avoid here is a difference of approach from one court to the next, or the issue having to be litigated on individual cases. What the court says they're trying to do is avoid prolonged or intensive inquiry on the issue of contributory negligence. And I've said there in the bottom bullet, query, is this really in line with the Act? Because what the Act requires is consideration of what is just and equitable, which it seems to me would suggest that one needs to look at each case on its own facts. But no, that is not how the Court of Appeal sees it. This, I should say, is broadly good for claimants, because insurers can't obtain anything better than a 25% discount, even in the clearest case of the injury being sustained wholly by the failure to wear a seatbelt. Of course, it's not truly wholly, because the defendant, the tortfeasor, has caused the accident in the first place. But it does seem a little bit harsh potentially on defendants and insurers, that even in those cases where the injury could have been avoided entirely and it's a very severe injury, 25% is the height of it. And likewise, insurers can obtain only a 15% reduction even where a relatively trivial injury was unavoidable, but the injury the claimant suffers is much more serious due to the absence of seatbelt. So if we take an example, if the claimant would have suffered a broken finger in any event due to the defendant's negligence, but suffers a life-changing injury as a result of the failure to wear a seatbelt, the reduction is still 15%. So Froome is extremely powerful. So the key questions for experts to consider, it's generally one, would the injury have been avoided entirely had a seatbelt been worn? And two, would there still have been some injury had a seatbelt been worn, but a lesser injury than that in fact suffered? And these questions are often mixed engineering and medical questions, and I know that Mr. Todd is going to touch on this in a few moments. Child seats, this is another category. Essentially, it follows Froome. If a child is the claimant and they've been put in a booster or a safety restraint seat that's been improperly fitted or installed or fastened, or they've been put in the wrong type of seat, then Froome applies. And there's a few cases here. I should note, by the way, that this isn't strictly contributory negligence, because it's not the claimant themselves, the child, who's been negligent. It's the adult who's put them in the wrong seat. So the legal mechanism here is under the Civil Liability Contribution Act of 1978. But from your point of view as experts, it's really no different. It's just, I note as a matter of law that we're looking at a slightly different statute to apply the same principle. So Hughes was a case where a 3-year-old child was severely injured when the defendant crashes into a car that's being driven by the claimant's mother. The mother had placed the claimant into a booster seat rather than a proper child restraint seat. If she'd been in the right seat, injuries would have been largely avoided, says the case report, and a 25% contribution was sought from the mother. Query here what largely avoided means, because and whether Froome has really been properly applied, because largely avoided makes it sound like there would still have been some injury, which means that 15% ordinarily, if you're applying Froome, would be the correct reduction. So it may suggest that in these contribution claims, on a background of inappropriate child restraint, the lines blur slightly. And in J, J was an unrestrained passenger on the mother's lap when the defendant caused an accident, Froome was applied, and there was a 25% contribution sought from the mother. Helmets, this is going to be another area that probably keeps many of you busy. Froome essentially applies once again. There's a few cases here, Connell and Jackson. The claimant sustained head injuries when knocked off his motorcycle. If he'd been wearing a helmet, they would have been less severe. So there still would have been some injury. The injury would have been less severe. Therefore, 15% reduction, applying the same principles as Froome. I should say this case actually predates Froome, but it's the same principle. Smith and Finch, the claimant was a cyclist who wasn't wearing a helmet. Even though helmets are not required as a matter of law, the claimant was contributory negligent for failing to wear one, and Froome was said to apply in general, albeit on the fact of that case, the helmet wouldn't have made any difference, so no deduction. Riding with a drunk or intoxicated driver, I suppose generally speaking, this is going to be less of an issue for experts and more of an issue for the lawyers, but as we're covering contrib in RTAs, I'll just cover this quickly. A patient who accepts a lift from a driver he or she knows to be drunk will be contributorily negligent if the accident was caused in part by the driver's impaired capacity to drive carefully. And there's a standard reduction in those cases of 20% per Owens and Brimmel. If the claimant is himself drunk, having been out drinking with the driver, for instance, then they're still contributory negligent, even if their capacity to judge the reasonableness of their own conduct is impaired. And there's a quote there from a High Court case of Campbell and Advantage, which was subsequently affirmed by the Court of Appeal on that point. I should just note that if a claimant accepts a lift from a drunk driver and fails to wear a seatbelt, it's not the case, and it's the case that injury would have been avoided but for the failure to wear a seatbelt. It's not the case that you add 25% to 20% to get to 45%. What court says is that you stand back and you look at the relative blameworthiness and causative potency as a whole. So in a case where those were the facts called best, the maximum reduction on those facts was 30%. So the question in these cases is whether the claimant knew or ought to have known that the defendant was impaired through drink. In Booth, this is an interesting case. The claimant knew the defendant had been drinking but had no idea how much. In the event, the defendant was found to have been twice over the legal limit. But the claimant wasn't negligent for failing to question the defendant closely as to how much he'd had to drink. He didn't appear drunk to the claimant. And there was no contributory negligence on that case. So the cases are still fact specific. Pedestrians, again, these are more cases for accident reconstruction experts and counsel on contrib probably than medical experts, but it's probably important to know this background. The court takes into account relative destructive power of motor vehicles versus human bodies. So there's a larger burden, a greater burden of care lying with motorists. And the leading case on that is Eagle and Chambers, which involved a teenager who's walking in the middle of the road effectively alongside a seaside resort at night. And she's struck by a drunk driver who's driving at 30-35 miles an hour. And the finding at first instance was 60% contributory negligence. And the Court of Appeal was unhappy about that and reduced it to 40%. And Lady Justice Hale, as she then was, essentially said that this isn't fair, bearing in mind the difference in relative destructive power between the vehicle and the pedestrian. I should say the slides will be made available after the talk for anybody who wants them. The last few minutes, I'm just going to speak a little bit about clinical negligence, which is my major area of practice. And this is something that we're seeing raised, contributory negligence in a clin neg setting, with growing frequency. I should say that it's still relatively rare, but it comes about, I think probably most typically in the case of claimants with chronic conditions such as hypertension or diabetes, who are non-compliant with the medication regime. So, but there isn't any reason in principle why contributory negligence can't be raised in clinical negligence claims. It is just rather uncommon. I think it's probably fair to say that in addition to those cases where claimants have chronic conditions, there's also potential for it to be raised where a claimant fails to seek advice when they reasonably ought to do so. Although I think generally speaking, it's going to be quite challenging for the defendant to raise it in those circumstances. But we're going to look at a few cases. Pigeon and Doncaster Health Authority, the claimant had brought a claim in respect of a cervical smear which was wrongly reported in 1988 as being negative, when in fact the smear was abnormal. In 97, she was referred to gynecology after she suffered heavy bleeding and carcinoma was discovered. And the defense raised the fact that the claimant had been asked by her GP to have 7 further smears between 91 and 97. If she'd done so, the condition would have come to light earlier. So the defendant pleaded in the alternative, first of all, that the refusal to undergo screening had broken the chain of causation and therefore there wasn't any good claim against the defendant. Secondly, that the defendant's responsibility ought to be limited in time until the point at which the claimant had been summoned for a repeat smear in 1991, or in the alternative, contributory negligence. And in her evidence, the claimant said that the reason why she was reluctant to undergo the test was because she found them painful and embarrassing. But she did acknowledge that there was a risk in not having the test, and she was aware of that risk. And the court considered all of this and ultimately found that the claimant was contributory negligent. Her repeated failure to undergo the tests, despite warnings from her GP, was blameworthy and also causative. And she was held to be 2/3 contributory negligent, which is really a rather high finding. And I think probably higher than one would expect to see in most clinical negligence cases where contrib is raised. There's a couple of other examples here on different facts. Sims was a fatal stroke case. The claimant had been seen by an independent GP for a DVLA assessment, who'd noted that his blood pressure was high. And there was the claimant subsequently, the deceased subsequently died of a stroke some years later. And there was a dispute of fact as to whether or not that independent GP ought to have advised the deceased, to see his own GP. The claim failed on the facts, but the judge indicated that had the claim succeeded, then there would have been a reduction of 25% for contributory negligence in failing to make a GP appointment, given that the deceased knew that his blood pressure had been high in the past. Spencer is a rather different case. The claimant had undergone surgery for inguinal hernia and sometime later had developed bilateral pulmonary emboli. And on discharge, he'd been advised to contact the hospital or GP if he had any problems, but hadn't been warned specifically about DVT or PE risk. He'd had pain in his calf muscles in the days following surgery, and it wasn't something that he knew to look out for. And the court ultimately found that there was no contributory negligence here. This was precisely the sort of risk that the defendant ought to have warned the claimant about. So it didn't sit well for the claimant to be raising it. Final case, a recent case of Dalton and Southend. This was a delayed diagnosis of breast cancer case. The defendant alleged contributory negligence on the basis that the claimant delayed in seeking re-referral to the breast clinic and didn't take reasonable care of her own health and welfare. The claim failed, but in respect of contributory negligence, Mrs. Justice Yip was rather unimpressed with the fact the defendant had raised this at all in the context of a case like this, and said, "I consider that the circumstances in which a finding of contributory negligence can properly be made in a clinical negligence claim will be rare. Certainly they do not arise here." So a warning shot perhaps for defendants there who are thinking of pleading contrib. The key points, the level of contributory negligence is a legal issue, which means it's an issue for the court. findings of fact are obviously for the court. Where there are differing factual outcomes, it's useful to give evidence on each, on the effect of each scenario in the alternative from the expert's point of view. It's for the experts to determine whether there would have been an injury but for the contrib, and whether there would still have been an injury but a lesser injury. In practical terms, it's always useful to know what the lesser injury would have been, even if we're within the rigid tram lines of Froome. Just bear in mind that the law is pretty rigid when it comes to the application of Froome to seatbelts and helmets and the like. Contrib is rare in clin neg, but cases are ultimately fact specific. That's 24.5 minutes, so I'm going to stop. I'll be happy to take any questions at the end, but for now, I'm going to stop sharing my screen and I'm going to hand over to Mr. Todd.
Hello, everybody. Holly, could I have, thank you, the first slide, please. So I'm going to, can we just go back one slide, Holly? Thanks. So I'm going to look at contributory negligence in the context of head and spinal injury, looking at these three areas, cycle helmets, belts, and airbags. I think it's important to understand the impact of a claim in contributory negligence, particularly in head and spinal injury. We can be talking about claims of great value. If one thinks about it from the claimant's point of view, if they lose 25% of their claim, then 3/4 of the way through their life, they run out of money. They run out of money for care, they run out of money for accommodation, support, income. The money just stops. On the other hand, of course, for defendants, if it's a multi-million-pound case and the insurance company doesn't have to pay out 25% of the claim, that can be over £1 million, which is a very handy addition to their balance sheet. So the stakes are high on both sides. Next slide, please, Holly. I think there are three key players in assessing this form of negligence. In head and spinal injury, of course, you need a neurosurgeon to say what was the nature of the head injury or the spinal injury. We need an engineer to talk about change in velocity, delta V, which I'm going to deal with in the next slide. And all of these other engineering aspects, the site of impact, the change in delta V, and the type of restraint or helmet that should have been used, because all of these influence the probability of the injury occurring and or its severity. And clearly we need lawyers. As Isaac has so very well set out, contributory negligence is an absolutely and ultimately legal concept, and it will be determined by the court. But there's another area I think is important, which is satisfying the test on a balance of probabilities. We're all familiar with this test, which means that you satisfy the test if it's more likely than not, 51% or more. Now, we'll see some examples subsequently where the failure to wear, for example, a seatbelt increases the risk of severe injury by maybe 5 or 6 times. And it's pretty obvious that the balance of probabilities test would be satisfied. But sometimes there's just a percentage increase or reduction in the risk of injury. And I think whether that satisfies the test on a balance of probabilities needs to be very carefully thought through. And of course, that is also a matter for lawyers. Next slide, please, Holly. So looking at delta V, it is obvious that the faster you travel, the more likely you are to die or be injured in an accident. But the important thing when considering delta V is to note that it's the change in velocity from immediately before to immediately after a collision, and this occurs in about 150 milliseconds, which in context is faster than you can blink. Next slide, Holly, please. And I want to illustrate that here. The top slide is a vehicle that's in collision with a concrete wall. It's actually a test at 60 miles an hour. And clearly delta V is 60 miles per hour in this rapid time of 150 milliseconds. But think of a car that's approaching traffic lights at 60 miles an hour and is slowing and will stop as the light turns red. Delta V is still 60 miles per hour. That's the change in velocity. But of course, it's occurring over a much longer time frame and there is no injury. So delta V is important, but we have to take delta V in context. Next slide, please, Holly. Now, for brain injury, we can look at the risk of injury in different brain injuries. So, as measured in terms of the crash severity, delta V, which here is in kilometers per hour. Perhaps you might want to look at particularly two of the curves. The blue curve is a concussive head injury, which is quite common. And the red curve is diffuse axonal injury, which is usually a severe form of head injury. And one can see that for all forms of traumatic brain injury, the risk of injury occurring, the probability of the head injury occurring increases with delta V. And for more severe brain injury, you need a higher velocity to cause brain injury than less severe brain injury, such as, for example, concussion. So there's a clear correlation between delta V and the probability of brain injury occurring, and we can quantify that, as you can see. Next slide, please, Holly. Let's look at crash helmets, cycle helmets. We know that wearing a cycle helmet reduces the risk of suffering any head injury of 51% and of suffering severe or fatal head injury by about 2/3. The reason why cycle helmets work is that they deform. The polystyrene lining of the helmet crushes and deforms. I'm going to show you a slide which illustrates this, but what this does is it reduces peak acceleration, and this gives more time for the head and the brain to slow down. So delta V is the same whether you wear a helmet or not. If you're doing 20 miles an hour on your bike and you collide with something, delta V is 20 miles an hour, but wearing a cycle helmet changes the impact of that head injury. Next slide, please, Holly. And this is linear acceleration plotted against time in milliseconds in a model where a helmet is not worn or is worn. And we can see the red line is not wearing a helmet, and the peak linear acceleration is 250. Whereas with a helmet, it's not only reduced to 150, but it is much delayed. So this is this takes us back to the slide showing the two, showing the car that crashed versus the car that slows and stops at traffic lights. That the lower the linear acceleration, the lower the severity of the injury, but the more time it takes to get to peak acceleration, the more the brain can tolerate that injury. Next slide, Holly, please. And looking at this in computer simulation, this is the head injury severity AIS grade. And we can see that AIS grade 1 and 2 are minor head injuries. 5, very severe head injury, and of course 6 is a fatal head injury. Using a computer simulation, it's found that wearing a cycle helmet will reduce the severity of head injury. So we know it reduces the probability of head injury, but we can now put some figures around it, reducing how severe the head injury is, and the reduction is 2 AIS grades. Now that's pretty important. If you look at AIS grade 4, somebody is unconscious for up to 24 hours with an open fracture, or 5 with a large hematoma. That could be reduced for the AIS 4 patient to 2, which is a minor head injury. So this is a big reduction. Next slide, please, Holly. I'm afraid this is a rather complicated slide. And essentially, if one looks at on the one axis, we have the severity of head injury in the AIS grade, and that's plotted against acceleration. The 2 bluey-purpley things are confidence limits, so forget about that. But the red line shows that there is a clear relationship between the force that's applied to the head and the severity of head injury. But for helmets, it's really the text that's important. Helmets are designed so that if you have an accident at or below 12 miles an hour, you should not suffer any significant head or brain injury. Above 12 miles per hour, the greater the speed, the greater the severity of injury. But the question that's unanswered is whether there's an upper limit to this effect. In other words, if a helmeted or an unhelmeted cyclist is hit by a car doing 50 miles an hour, does it matter whether they were wearing a cycle helmet or not? And it's probable, science isn't very good, but it's probable that the upper limit of effectiveness of a cycle helmet is about 18 or 20 miles an hour. Next slide, please, Holly. Now, another factor to take into account is the nature of the brain injury. So we distinguish coup injuries, which are brain injuries occurring, skull or brain injuries occurring at the site of impact. Contra coup injury are injuries occurring on the side opposite the site of impact. And then there's rotational injury, which causes diffuse axonal injury. Next slide, please, Holly. And just a few examples of that. Top left, I hope people can distinguish the skull fracture. Unfortunately, I can't show it to you because I don't have control of my mouse. Top right, we see an extradural hematoma, which is caused by direct injury to that part of the head. Bottom left, bifrontal contusions are the classical contra coup injury where the victim hits the back of the head and suffers damage to the frontal lobes of the brain. And then bottom right, we have a diffuse axonal injury pattern of injury. And what is being demonstrated here is microhemorrhage on an MRI. But the clear point is that these are occurring in a diffuse way throughout different parts of the brain. Next slide, please, Holly. And this is important to the probable benefit of wearing a helmet. A cycle helmet mitigates some but not all brain injuries. Coup injuries are protected better than contra coup injuries. And we think there is probably no effect upon diffuse axonal injury, although the truth is that the standard cycle helmet test, the British standard, doesn't test rotation. It just tests direct impact. So we don't really know. There's a very limited literature which suggests that wearing a cycle helmet might be harmful in diffuse axonal injury because the helmet increases the mass of the head. But that's not, that's speculative. Next slide, please, Holly. So I'm now going to turn to cars, seatbelts, airbags. And I'm mainly going to talk about spinal injury. I will just also talk about a form of primary brainstem injury at the end. And at the bottom, we can see a CT scan which shows a fractured dislocation at C5-6, and bottom right we can see damage to the spinal cord. In fact, that's at C4-5. It's a different patient. But seatbelts considerably reduce the likelihood of a patient, of a victim suffering a spinal cord injury, and that's true for all subtypes of spinal cord injury. In this paper that I'm quoting here, they looked at about 1,000 spinal injuries occurring over an 18-year period, and the probability of that occurring if you're wearing a seatbelt is 0.027%, but if you're not wearing a seatbelt, it's increased by over 5 times. So if you don't wear a seatbelt and you suffer a spinal injury, there's a strong probability that it will be found that if you'd worn the seatbelt, you'd have been okay. Next slide, please, Holly. So we've looked at the probability of spinal cord injury. Now let's look at the severity of injury. And this is a standard grading system. The Frankel grading system, we now more commonly use a major grading system, but it doesn't matter. And it goes from Frankel A, which is complete motor and sensory paraplegia, to Frankel E, which is no neurological deficit at all. And in this particular paper, it was found that you would suffer no spinal cord injury 61% of the time if you were wearing a belt, and only 43% were as good as Frankel E if they did not wear a seatbelt. This is where I say we need to think about the balance of probabilities. That doesn't seem to be a big change from 61% to 43%, although for Frankel A it's much more obvious, because the risk of you suffering complete motor and sensory paraplegia is 4 times more likely if you do not wear a seatbelt than if you do. Next slide, please, Holly. We can look at these things, no, more than we can. We need to look at these things in combination. Some patients have no restraint at all. In some, there is both a belt and an airbag, and the belt is worn and the bag deploys. And one can see that in these 2,500 road traffic accidents, the probability of suffering any form of spinal injury of any severity was 48% with no restraint, belt or belt plus bag about 6%, but in airbag alone, it was 19%. And we can look at that in a bit more detail. Next slide, please, Holly, which is an interesting observation. And we're now looking at odds ratios, which are the probability of a spinal cord injury occurring if you do or do not wear a belt or a bag, does or does not deploy. So the odds ratio of spinal cord injury occurring if you are wearing a belt and the bag deploys is 0.41. If you do not wear a restraint of any kind, no belt, no bag, it's 2.51. But if the airbag only deploys and you're not wearing a belt, in this particular study, the odds ratio was 4.2, much higher than if you're wholly unrestrained. Now that may appear counterproductive, but I don't think it is, because the mechanism is probably hyperextension, but whether it's hyperextension or any other type of neck movement, the point is that if you're not wearing a seatbelt and the airbag deploys, as the body is thrown forward, the chest stops, the torso stops as it contacts the airbag, but the head and neck continue forward because that part of the body is not restrained by a belt. So the airbag but no belt seems to be a particularly hazardous form of injury. Next slide, please, Holly. Okay, I said I'll just touch upon primary brainstem injury. This is direct injury to the brainstem in the absence of diffuse axonal injury in the brain generally. And these are commonly fatal injuries, but the importance is that if they're not fatal, they are usually very severe injuries and damages will be very high. Taking all of them into account, both fatal and non-fatal, we can see that the unbelted victim is over 2.5 times more likely to suffer this injury than somebody who's wearing a belt. But just as we wondered earlier whether there might be an upper limit for the effect of a cycle helmet, we need to consider whether there's an upper limit for seatbelts. These are usually very high-speed accidents. The severity of impact is severe. Only an engineer can tell us if at these very high velocities, the seatbelt would fail and the injury would not have been prevented. But it's a question that needs to be asked and answered in these very high-speed accidents. Next slide, please, Holly. I'm coming to the end, and I'm going to go through this pretty quickly. There are many other factors that determine whether there is likely to be an injury, a brain or spinal injury, and how severe it is. It depends on the position in the vehicle. Front seat, rear seat, the risk is different. The risk is different for different types of impact. Rollover injuries are usually very severe. There's a difference between other sites. We've dealt with velocity of impact, delta V, but just to re-emphasize that delta V is not something that's absolute. It needs to be taken in context. The type of restraint that should be worn, cycle helmet, a belt, and so on. Belts can be fitted with pretensioners or load limiters, which change the risk patterns of injury. The type of vehicle is important. One of Newton's laws tells us that heavier objects accelerate and decelerate less than lighter objects. So the heavier the car, the slower the deceleration, and we've seen previously that the speed of acceleration, deceleration is an important determinant of injury. Essentially, the longer you take to decelerate, the less likely you are to suffer an injury or a severe injury. And the risks are different for men and women and for younger and older people. Next slide, please, sorry. And this is the last slide. Just a few quick conclusions. Delta V is important, but there are other factors that need to be taken into account. Helmets are designed so that if you come off your bike at up to 12 miles an hour, you should not suffer a significant head injury. Above that, you're more likely to suffer injury, more severe injury, but is there an upper limit where not wearing a cycle helmet actually doesn't make a difference? And that's not settled, but it needs to be thought through. Helmets reduce the severity of head injury by 2 AIS grades. Seatbelts and airbags reduce both the frequency and severity of spinal cord injury. And we've seen that not wearing a seatbelt with an airbag that deploys may be particularly hazardous in respect of spinal cord injury. And that's it. Thank you very much indeed.
I can't see that we've actually got any questions from anyone. Is that right? We don't have any engineers, I don't think, in the audience to tackle you, Nick, on certain aspects. I'm a clinical negligence specialist, so it is news to me that the law in road traffic in personal injury cases is pretty blunt in terms of as you say, Isaac, you should be looking at the equity of the situation, and presumably you should be able to apply that percentage which fits those particular facts, but it seems pretty blunt.
Very much so, and I think it means that if contrib is raised in a clin neg setting, everything is to play for, considering that the degree of contrib in pigeon was as high as 2/3 for a claimant who didn't want to attend for smear tests. It can really be anything, and it's effectively it's one of these things where it's going to come down to the individual tribunal. So there's always going to be, in a case where there is going to be a finding of contrib in a clin neg background, there's always going to be significant risk on both sides as to what the level is likely to be. And all you can do is look at other cases and try to draw what appear to be sensible conclusions. And I should say that is the case for the majority of personal injury litigation. It's only in the context of RTAs that we really have these very rigid guidelines. If one's looking at employers' liability or public liability type situations, then again, you're stuck looking through the body of case law to see what other judges have done in the past. So it gives us a bit more room for negotiation and creativity.
Yes, I don't know whether you uncovered any other clin neg cases, but certainly I've entered into settlements where we've had to take into account that there may be a risk of some small deduction. And
it generally just goes into litigation risk, doesn't it? Rather that you wouldn't normally explicitly acknowledge contrib when settling a clin neg case, unless there were a very good reason to do so. I'm trying to think other scenarios where I've had it raised. I mean, I think very occasionally it will be raised for where there's been advice on discharge to reattend if X, Y, or Z happens. But for most of those cases, I think it's been raised in correspondence and then not followed through in the pleading. But it's cases, diabetic or hypertensive patients who don't follow the medication regimes. I think those are the ones where there's more room for argument.
Yes, and I suppose sometimes people say about obesity or smokers even, which is a much more generalized sort of allegation. But I see there's a question for you, Isaac, from Dr. Bellman.
Yeah. So in a case about delayed diagnosis, is the parent's failure to attend appointments in relation to a child contributory negligence? The answer is no. It is the same as with the child seat issue. It would be a contribution sought from the parent. So what the defendant would have to do is bring the parent or guardian in as a third party and claim a contribution from them. But again, that's really a legal issue, and the sort of considerations the court will be looking at are the same as if it were a matter of contributory negligence. Was the failure to bring this child in on the part of the parent or guardian something that a reasonable parent or guardian in that situation ought not to have done? That's really what you're looking at. But not strictly contrib, but really the same thing, a contribution.
The parent won't be making up the loss there, as opposed to a road traffic claim where the parent's culpable. And Stuart Young rightly points out that in psychiatric cases, the risk of suicide is also something that we're increasingly having to take into account.
There's some case law on that, and it can be a very high degree of contrib, 50% plus, if there's suicide. But again, it is fact specific.
Well, I don't think we've got any other questions. And Nick, you've got off lightly with that one. And thanks very much indeed for your very full talk about the medical aspects. And thank you both very much indeed for assisting us. And thanks everyone for attending, and I hope you found it enlightening.